Taxation, Tax Administration, Remedial Matters Bill, second reading.
Mr. Speaker.
Mr. Chairman, call on Government Order of the Day number 3. I declare the House in committee.
Child and Family Protection Bill, committee stage.
I declare the House in committee for further consideration of the Child and Family Protection Bill.
Order. The House and Committee for further consideration on the Child and Family Protection Bill. Members, leave was given to take all the provisions of the bill as one question. When the debate was last interrupted, the Honourable Damien O'Connor had the call and has 3 minutes and 36 seconds remaining if he wishes to the call. Does anyone else wish to take the call? Charles Chevelle.
Chairman, I'd just like to call attention to the 2 supplementary order papers that sit in the name of respectively Lynn Pillay and Jacinda Ardern, both of whom were members of the committee, the Justice and Electoral Committee that is, while this bill was being considered in Select Committee. And I would be very interested in hearing from the Minister in the Chair about the government's attitude to both of these supplementary order papers. I recall assisting Ms Pillay and Ms Ardern at the time that they put these forward back in November 2010 with the drafting of them, and I do want to commend both of the supplementary order papers to the House because I think they would make sensible and helpful changes to the legislation, and it would be, I think, helpful given the spirit of cooperation which has surrounded this legislation to date, if the government were to support the supplementary order papers as well. Sir, the first one that I want to deal with is the one that sits in the name of Jacinda Ardern, that supplementary order paper number 179. What that supplementary order paper will do is amend the bill so as to change the definition of a child in the Domestic Violence Act 1995 from a person under the age of 17 years to a person under the age of 18 years. Now, that would bring the proposed legislation into consistency with the United Nations Convention on the Rights of the Child, to which New Zealand is a signatory, and also the definitions that currently sit in the Care of Children Act 2004 and the Children's Commissioner Act 2003. Now, Sarah, I would have thought that that was a very logical thing to do here. There is no particular common sense surrounding the choice of an age of 17, which is what the legislation plumped for as drafted. And if the Minister thinks that there is any particular compelling reason to defy our international obligations and to legislate inconsistently with 2 important existing pieces of child welfare legislation, then I think the Committee of the Whole ought to hear what that justification is. And if the Minister doesn't know because he's had to take the chair on behalf of a colleague, then I do note that he has the assistance of officials available to him, and I think it would be a very helpful thing, as I say, as well as consistent with the spirit with which this legislation has been advanced. It's been cooperated in by certainly the Labour opposition, to hear why this inconsistency continues to be supported by the government. So the second supplementary order paper that I referred to and wish to now speak a little bit more about is the supplementary order paper that sits in the name of Lynn Pillay. That's supplementary order paper number 178. Lynn Pillay chaired the Justice and Electoral Committee for 3 years in the previous Parliament. I think her views are entitled to some weight. She wouldn't have put this forward unless she'd given it a good deal of thought. And her supplementary order paper is designed to try to provide a bit of some enhanced protection for the children of applicants under the Domestic Violence Act 1995. The supplementary order paper would amend the Child and Family Protection Bill so as to provide that protection orders would continue to protect a child of an applicant's family after they reach the age of 18, whether or not they reside with the applicant. And Sarah, I think it's important to note that in this context, we're talking about young people who've been exposed to a considerable degree of acrimony and violence, and may still be in the future. And the supplementary order paper is very consistent with the general aims of this legislation, because it would continue to extend, Mr Chairman, it would continue to extend to young people some protection until they themselves decide that a protection order is no longer required. And after all, maintaining an existing order is surely more efficient. We hear from this government on many occasions in this field of justice and law and order that they want greater efficiency. Well, it's much more efficient, quite plainly, to extend an existing order rather than requiring young people to go to the expense and trouble and paperwork and judicial time and lawyer time involved in having to apply for a new order simply because they reach an arbitrary age that's been arrived at by the text of the bill. So, Mr Chairman, I do hope that the Minister will feel able to take a call on these two issues. Obviously, we're not asking that he do that instantly if he wants to take some time to take some advice from his officials. But we have put these supplementary order papers forward in good faith. Further to, I think what is fair to say, the weight of evidence that the Justice and Electoral Committee heard from submitters. These are measures that are designed to try to improve the overall efficacy of the bill and to ensure that we legislate as a Parliament consistently both with our international obligations and with other existing legislation in force in this field. So if we are to depart from those practices, we should know why. There should be a proper justification advanced for that. And on the second question, we ought to not miss an opportunity to continue to provide the sort of protection that this legislation is designed to do, to provide without proper justification. And if we're going to be efficient about the way we do it, we should extend orders in their in-force state until such time as the people who are protected by them actually tell the court they no longer need that protection. So if we're to do differently than either of the SOPs, I do think there ought to be a case, because I don't want the opposition to have to rethink its support for the substantive legislation.
The Colchester Boroughs.
Thank you,